Hereby call this meeting to order. This is the Code Enforcement Special Magistrate meeting for the City of West Palm Beach. Good morning. My name is Kevin Wagner, and I'm going to be the Code Enforcement Special Magistrate for today's hearing. I want to begin by explaining how the process is going to work. Generally, I hear the building code cases on the agenda first. Then the city will call the cases as they appear on the agenda. If you've appeared at today's hearing, which would be true if you're sitting here with me, your case will be called before those cases where no one has appeared. However, this is only true if you have signed in. So if you haven't signed in, please check with one of the officers in the rear of the room and make sure that you get signed in. Once your case is called, I ask that you come down to the podium on my right-hand side, which is right over here. The city will come over here and they will present their testimony and evidence first, after which time you'll have the opportunity to review the evidence and ask questions of any of the city's witnesses. You'll also have an opportunity to testify and present me with any of your own evidence. Once I have all the testimony and evidence, I will make a ruling. I will enter a written order either today at the hearing or in the next few days, which you will receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not a formal courtroom. The formal rules of evidence do not apply here. Now, although this is not a formal courtroom, all testimony given today is taken under oath under penalty of perjury. So if you're going to testify, or you think you might testify, or there's a possibility that you might testify, would you please rise and raise your right hand? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida?
Yes, sir.
All right, the city can call their first case.
Agenda item number 1, case number is CE 22030423. Case address is 1481 7th Street.
This is 1. Go ahead, sir.
Tom Moore, Development Services. This is 1481 7th Street. I don't know if there's any pictures we can put up of the garage roof. It originally started as a code complaint, and the owner was getting out on the flat roof, spending time out there. It was considered unsafe conditions, so we were asked to get involved. They had applied for a railing for the top of the garage. It's a flat roof, but he never could get it out of plan review. So
he applied for the permit to put a railing up there?
He did apply for the permit.
But it has not been issued?
In December of 21.
And it has not been issued?
Has not been issued. He's struggling with engineering and the cost of it. He claims he can't afford it. It was posted on July 12th. He did receive the mail. I've been in contact with him. The two sliders on that south side may have been windows when it was built. We don't know. But furthest back we found is 2009, and they were sliders at that time. So what we're going to do is he's going to double lock the doors. It's not a rental. He lives there, and we're going to double lock the door. He's going to send me pictures, and we're going to safeguard it that way.
So what does he need to do to come into compliance?
Put some extra locks on the door, screw it shut, show me something, get it to me, and we'll be done with that.
Because you cited him for failure to obtain a building permit.
Well, that was the railing permit. I'm going to take that back, I guess, and just let him safeguard the openings.
So what are you asking me to do?
Just agree to 30 days to safeguard the situation.
All right, let me do it. Well, before I do that, let me just ask you quickly. You did notice through posting and certified mail?
Yes.
You posted the property and the city hall?
Yes.
Okay. Do you have any questions?
Do the photos that you've shown accurately and truthfully depict your observations of the property?
Yes.
Thank you.
Would the city like to submit those in evidence?
Yes, please.
Yeah.
Please submit as evidence the notice of violation and affidavit of posting and the photographs.
I hereby accept in evidence the photographs and the documents identified by council as City's Composite Exhibit 1. All right, in case CE 22030423, I'll make the following findings of fact and evidence. I find the notice is sufficient I find the property is in violation of 105.1. The property needs to come into compliance within 30 days, either by securing the property or obtaining the permit. I'm sorry, what fine were you seeking here?
$50 a day.
Or a fine of up to $50 per day may issue.
Agenda item number 26, case number is CE 22060295. Case address is 413 Plymouth Road.
Good morning.
Good morning.
Richard Pazmino, City of West Palm Beach Code Enforcement. This property was cited on June 24th. Certified mail was sent out June 27th. And in addition, the property and City Hall were both posted on June 29th. It was also sent first-class regular mail. This property was cited for a repeat violation for hurricane hazard, overgrown trees and power lines, trees, hedges obstructing the right-of-way, cleanup to the center of the right-of-way, trash and debris, and excessive growth. This is a repeat for case CE 21050378. That was given an order on June 16th, 2021. It was found out of compliance on July 1st, 2021. I have had contact with the resident. He's here today. The property was first noticed out of compliance June 21st, and it came into compliance July 8th. That's 17 days out of compliance. The city's asking for $75 a day for every day it was out of compliance. That's $1,275.
Sir, can you tell me your name, please?
My name is Robert Mesa.
And what is, I'm sorry, you said Robert Messon?
Mesa.
Mesa.
M-E-S-A.
And what is your relationship to Juan Mesa?
I'm his son.
So your father is the owner of the property?
Yes, but it's in my mother's name. He passed away 6 years ago.
And you live at the property, sir?
I'm sorry?
Do you live at the property?
Yes.
So the city says that, that you haven't been maintaining your property and that this is a repeat violation. What do you say?
I had a lot on my plate ever since my father passed away. I take care of my mother, as well as have my own health issues. I forget from maintaining.
So what are you asking me for? The city says I should fine you $75 a day, which actually is less than they could have asked for. They could have asked for up to $500 per day.
Well, I honestly don't really know what to say, sir.
Well, you have to ask me for something, otherwise I have to go with what the city has.
Lower, I guess?
I'm sorry?
Possibly lower? We don't really have much money, sir. That tree alone cost us half our bank account.
All right, this is what I'm willing to do. If you will commit to me that you will maintain this property in the future and the city will not have to go out there and enforce this, I'll reduce the fine to $25 a day for 17 days, which my math comes out to is $325? Did I do the math right? Somebody help me out here.
I think so.
$425? All right, which is considerably less than the $1,200 the city wanted to give you. But I'm going to only do it if you commit to me at this moment that you're going to maintain this property.
I will.
All right.
Mr. Special Magistrate, we would like to submit our documents as evidence if the respondent
go
has
ahead.
no objection.
Yeah, the prior affidavits and orders are in there, are in the case file.
All right, without objection, I'll accept in evidence the documents submitted by council as city's composite exhibit 1. In case CE 22060295, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of the listed code sections. I find the violation constitutes a repeat violation under the code of the ordinances of the city of West Palm Beach. I hereby order a fine in the amount of $25 a day for 17 days out of compliance for a total fine of $425. All right, thanks for coming in.
Thank you.
Agenda item number 7, case number is CE 22050139. Case address is 609 Ivernia Street.
Morning. Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 609 Ivernia Street was initially cited on 5/12/22.
Hold on one sec. Which number are we? 7. Sorry, I misheard.
Okay. Property 609 Ivernia Street was initially cited on 5/12/22. Certified mail was sent on 5/13/22. We do have documentation of the certified mail arriving at the property owner's address. The property as well as City Hall was posted on 5/16/22. Property was cited for 18105J, non-residential paint. And as of last evening, the property still remains in violation. The city's requesting 90 days additional in order to come into compliance, or a fine of $50 per day be imposed.
Sir, can you tell me your name, please?
My name is Michael Omar Frazier.
I'm sorry, one more time, sir.
Michael Omar Frazier. Michael Frazier.
Michael Frazier, okay. Sorry. Mr. Frazier, what is your relationship to the owner, Samar WPLC?
I'm the property manager and the photographer for the company.
You're the property manager and photographer?
Correct.
I know I might regret asking this, but why does a property need a photographer?
I run a lot of their other properties. That I'm the photographer for the other properties, and for this specific property, I'm the property manager.
Okay. All right, so the city says that you're missing some paint here. What say you?
When we found out, we just basically we've been doing work to the property. It's just been taking us a little while longer because of the weather. We had closed down for a little while, so we're getting things together. It's just a lot of work to do to get the whole building painted. So we're just requesting a couple more, just a little bit more time to do it because we have started. We just need
City's
more
offering
time.
you 90 days. What do you think?
Excuse me?
City's offering you 90 days.
That's fine.
You want to submit your docs?
Yes, we'd like to submit our documents as evidence.
What are our docs here? We got photos?
We have an affidavit of posting, the certified mailing documents, notice of violation, and the photographs of the property.
All right, without objection, I'll submit those into evidence as City's Composite Exhibit 1. In case CE 22050139, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18105J. Give the respondent 90 days to bring the property into compliance, or a fine of up to $50 per day shall issue. So you have your 90 days, but don't dawdle, because that fine starts pretty quick.
Thank you.
Yeah, you're all set. Okay, don't believe there's any more respondents in the, okay.
I think this may be a record for the least number of respondents.
Moving on to agenda item number 2, case number is CE 22050260. Case address is 525 31st Street.
Good morning, John Frosca, West Palm Beach Code. This property was declared a chronic nuisance on May 23rd of 2022, and the property was posted, and the declaration was sent out requesting that the owner submit an action plan sufficient to curtail the nuisance activities. At that point, time was up, did not submit an action plan, did not respond. So notice of violation, notice of hearing was sent out on June 22nd of 2022, and the property was posted for notice of violation, notice of hearing. As you can see from the pictures, this property is
Mess.
yes, it's a filthy, unsanitary mess. And
Have you had any
And to
contact
further
with the
the-
owner at all?
there are fines running on the property, 2 different code cases for that. And I know that the law department sent out a demand letter to the owner, and if council wanted to speak further on that. But, the city would be requesting a service order to be entered against the property and allow us to abate the services that are needed, cutting and cleaning, boarding, securing.
How many adjudications have previously occurred on this property?
I'm sorry, I couldn't hear you.
How many adjudications of code violations have occurred on this property?
Since he's owned it, 1, 2, 3, 4 cases prior to that. But this is based, on property maintenance and keeping the property clean and secure. So that's why I referenced the one case, and, it's pretty evident.
And that case is still open?
Yes, it is.
I'm sorry, counsel?
Your file reflect an executed affidavit of posting,
Yes, ma'am.
and was the notice of violation sent via certified mail?
Yes, it was. It not only sent to the tax roll, but to the owner's address, home address.
And was it posted at the property?
Yes, it was.
And notice was posted at City Hall?
Yes.
And do the photos in your file accurately reflect your observations of this property?
Yes, they do, ma'am.
We would like to submit as evidence are the notice of violation, certified mailing documents, affidavit of posting, and the photographs.
Without objection, I'll accept those documents as evidence of City's Composite Exhibit 1. So you're just looking for a service order here?
Yeah, formal declaration, magistrate, and the service order.
All right, in case CE 220500260, I make the following findings of fact and law. I find notice is sufficient. I hereby find that a pattern of nuisance activity exists on the property. I affirm the city's declaration that the property is a chronic nuisance, and I hereby enter a chronic nuisance service order authorizing the city to perform any nuisance abatement services that are needed on the property and to charge the cost of that abatement against the property and property owner.
Thank you very much.
Agenda item number 3, case number is CE 22050211. Case address is 941 Allendale Road.
Good morning, Sonny Ben, City of West Palm Beach, Code Enforcement. This property was cited on May 19, 2022. The notice of violation was posted at City Hall and the property on May 20th, 2022. Certified mail was sent on May 19, 2022 and received. The property was cited for broken window in the front of the property. I have not made contact with the property owner. This property is still in violation of Code 18103E, and the city is requesting an additional 45 days to gain compliance, or $50 per day until compliance is achieved.
I'm sorry, how much of a fine were you seeking?
$50.
$50. Counsel?
And do these photos accurately depict your observations of the property?
Yes.
Special Magistrate, we would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll enter the documents and evidence of City's Composite Exhibit 1. You said you haven't had any contact with the owner?
Correct. No contact.
Is somebody living here?
Yes.
All right, in case 18103E, I'm sorry, in case CE 220500211, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18103E. Respondent has 45 days to bring the property in compliance or fine of $50 per day may issue.
Thank you.
Marcus, am I still tabling number 4? Yes? You here? Okay. There was somebody here from number 4, but they are at Development Services, so we will skip and come back to it. Agenda item number 5, case number is CE 220500351. Case address is 634 37th Street.
Don Williams, Code Enforcement, cited this property on May 28th of 22. Certified mail sent out on June 23rd of 22. And property was posted in City Hall July 6th of 22. This property was cited for 18106A, clean and unsanitary condition, 18106B, excessive growth, 71-8, obstruction of the right-of-way. I had contact with the property owner this morning. He showed up actually for the hearing, but we came to agreement to give him an additional 30 days or a fine of $50 per day.
I'm sorry, you said 30 days or
Or
250?
50.
250?
50, just 50.
50, just 50.
That's it.
Want to do the docs?
Yeah, does your file reflect an executed affidavit of posting?
Yes, it does.
And do the photos that we have reviewed during your testimony accurately reflect your observations of the property?
Yes.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll enter those in evidence, the city's composite exhibit 1. Are you using 78-1 is about the hedge that's
Yes,
that's blocking the sidewalk, is that it?
Yes. Mhm.
And you observed trash and debris on the property?
Correct.
And I can see a lot of excessive growth. Any evidence that the respondent has tried to do anything here?
Well, he showed up this morning. He said he doesn't have the funds, but he's going to work on that and make sure he get it done.
You think 30 days is enough time?
Yeah, he said 30 days, what he needed.
All right, in case CE 2205035-1, I make the following findings, fact and law. If I notice sufficient for the property in violation of 18-106A, 18-106B, and 78-1, respondent has 30 days to come to compliance or fine of up to $50 per day may issue.
Agenda item number 6, case number is CE 2206-0206. Case address is 936 York Street.
Don Williams, Code Enforcement, 936 York Street, was cited on June the 16th of 22, certified mail, and was sent out June 24th of 22. The property was posted in City Hall of June 17th of 22. I cited this property for 18-100, which is safe egress, 18-103A, repair windows, and 18-103C, interior walls or ceilings, 18-103I, equipment maintenance, and 18-106E, exterminate, 18-95A, electrical, and 18-96A, ventilation standards. The property owner is working on the violations, and they almost completed all of them, so they need additional 15 days to comply all the violations, but they are working diligently on them.
And the fine amount?
$50 to, I'm sorry, $100 a day.
Counsel?
Yes, was this posted at the property?
Yes,
Okay. And do these pictures represent your observations of the property?
yes.
We would like to submit as evidence a copy of the notice of violation, the certified mailing documents, affidavit of posting, and photographs that have been presented.
Without objection, those documents are entered in evidence, the city's composite exhibit 1. So what is outstanding here?
I haven't inspected anything, so I consider all of them outstanding, but they're working on them.
But they're making good progress, as far as you can tell.
I'm sorry, I can tell. They sent me a couple of videos. They have unscrewed the windows, which is the safe egress
Well, that's
violation.
good.
The windows are now no longer screwed together. Let's see. The AC was removed that was leaking water, which is 18-103I, equipment maintenance. That also was removed.
Seems like a lot to do here. Are you sure 15 days is a sufficient amount of time?
Yeah, they've been working on it. They're almost completed.
All right. Okay, CE 22060206, I make the following findings of fact and law. I find notice is sufficient from the property in violation of the code sections 18100, 18103A, 18103C, 18103I, 18106E, 1895A, and 1896A specifically. The windows are screwed, the doors are not weather tight, the interior ceiling is in disrepair, the AC unit is in disrepair, the smoke detector is not working, there are evidence of rodents on the property, there are electrical outlets that are not working or are exposed, and there is not proper ventilation in the bathroom. Respondent has 15 days to bring the property in compliance or fine of up to $100 per day may issue.
Thank you.
Agenda item number 4, case number is CE 22040228. Case address is 307 34th Street, and it is being rescheduled. Agenda item number 8, case number is CE 22050244. Case address is 1650 Mercer Avenue, Unit A1.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 1650 Mercer Avenue was initially cited on 5/20/22. Certified mail was sent on 5/23/22. We do have a signed certified mail receipt on file. The property, as well as City Hall, was posted on 5/24/22. Property was cited for 18105J, non-residential paint, 22-32-A, certificate of use, and 82-144 business tax receipt. As of last evening, the following sections have complied: 22-32-A and 82-144. 18-105J still remains. Upon speaking to the property manager on last evening, Natalie Ridlewski, she indicated that they have secured a contractor to complete the painting. There's no reason to believe that it won't be accomplished, but the city's requesting 90 additional days in order to comply, or a fine of $50 per day be imposed.
Do
Yeah.
these photos accurately reflect your observations of the property?
Yes, they do.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and the photographs.
Without objection, I'll enter those documents and evidence as City's Composite Exhibit 1. And in CE 22050244, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18105J, specifically the building needs paint. Hereby give the respondent 90 days to come into compliance or a fine of up to $50 per day. May I issue?
Thank you.
Agenda item number 9, case number is CE 2203-0399. Case address is 623 44th Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on March 23rd. Certified mail was sent March 24th. Certified mail was received April 4th. City Hall was posted April 5th. This property was cited for clean and sanitary, garbage can placement, junk abandoned vehicle, sod of swells, sodding of the yard, parking requirements, and outdoor storage. As of yesterday, all remaining violations were clean and sanitary and outdoor storage. I've had communication with the property manager who advised me those things would be taken care of, but they haven't as of yet, so the city is requesting additional 20 days or $100 per day after.
Was the notice of violation posted at the property as well?
Yes,
And do the photos that we're reviewing during your testimony accurately reflect your observations of the
Yes.
property? The city would like to submit as evidence the notice of violation, certified mailing documents, affidavit of posting, and the photographs.
Without objection, I'll accept those documents and evidence as City's Composite Exhibit 1. So we just have clean and sanitary because there is still trash and debris on the property, is that
yes,
correct?
there's trash debris all on the west side of the driveway and around the swell, and there's still an abundance of outdoor storage that's outside, including boards, tires, all sorts of things outside.
And you believe 20 days is a sufficient amount of time for them to clean this up?
Yes, sir.
All right, in case CE 22030399, I make the following findings of fact and law. Fine. Notice is sufficient. I find the property in violation of 18106A and 9471C. Respondent has 20 days to come into compliance. Well, I should say. Specifically, there are trash and debris on the property, and there is also outside storage, including tires and boards on the property. Respondent has 20 days to come into compliance or a fine of $100 per day. May I issue?
Agenda item number 10, case number is CE 22040126. Case address is 420 42nd Street.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on April the 5th. Certified mail was sent April 14th. Certified mail was returned April 20th. City Hall was posted April the 5th. This property was cited for paint, sodding of the swells, sodding of the yard, and outdoor storage as well. So far at this moment, the only thing that's come into compliance was painting. The sodding of the swell is still outstanding. Sodding of portions of the yard where they had concrete are still outstanding, and the outdoor storage. I've spoke to this homeowner, and he's requested 60 days just to have the gravel removed out of the swell, as well as the concrete removed out of the yard, and that he would have it all taken care of after 60 days.
Was the notice of violation also posted at the property?
Yes,
And do the photos in the file accurately depict your observations of the property?
yes,
Special Magistrate, we would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents as evidence as city's composite exhibit 1. So he painted the place, but he hasn't done the sodding for the swale or the landscape, and there's still outdoor storage?
Yes, sir. It was kind of peculiar to me, but that's exactly what he did. He painted and. it's
You know, you
nice,
don't see
but-
that typically. Painting is usually the last thing they do.
Yeah, it used to look real bad, like the green, the moldish dew colors and all that. And he painted all that, but.
Hmm.
it didn't
What's
touch a
what's
rock.
the outdoor storage?
There's buckets and boards and car wash material all spread through the concrete portion of the yard. Once you get to those images, you'll see them all on the west side of the property, as far as on the east side as well.
And the 60 days was what they requested?
He requested 40, but I didn't think that would be enough time, so I just requested the other additional 20 for him.
And you didn't say what level of fine you were seeking here?
That was $100 a day after.
All right, in case CE 220400126, I make the following findings of fact on live fine notice is sufficient. I find the property in violation of 7894C, 94442C1, and 9471C, specifically that there's missing sod both in the swale and other landscaped areas, and there's outdoor storage consisting of bottles and other debris. Respondent has 60 days to bring the property into compliance, or a fine of up to $100 per day may issue.
Agenda item number 11, case number is CE 22050180. Case address is 960 34th Street.
Good morning. J. Francis, West Palm Beach Code. 960 34th Street was cited on 5/17/22. Certified mail was sent on 5/18/22. Both the property and City Hall were posted on 7/7/22. The affidavit of posting was completed. This property was cited for landscape maintenance, garbage can placement, and acquiring a fence permit. I have been in contact with the daughter of the owner. Since the owner is an elderly lady. As of this morning, the property has come into compliance with the garbage can placement. However, the fence permit and landscape maintenance is still pending. Therefore, the city is asking for an additional 60 days for them to come into compliance. If they do not come into compliance, then the city is asking for a $50 a day fine until compliance is achieved.
Did you say 60 days?
Yes, sir.
And do these photos accurately depict your observations of the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, the certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents and evidence the city's composite exhibit 1. So the landscaping, I guess, is that looks like it's missing a bunch of sod there, huh?
Yeah, it's a big area. She can't do it herself, so she have to wait for her daughter.
And so the fence, that's a new fence that was never permitted?
Yes.
Did they indicate that they're gonna try and get that permitted?
She told me she had put the application in, so she's waiting.
All right, in case CE 220500180, I make the following findings of fact on live. Fine notice is sufficient from the property in violation of 18106K and 94302A3. Respondent has 60 days to come to compliance or fine of $50 per day may issue.
Agenda item number 12, case number is CE 22060091. Case address is 3406 Greenwood Avenue.
Good morning, J. Francis, West Palm Beach Code. 3406 Greenwood Ave was cited on 6/9/22. Certified mail was sent on 6/10/22. Both the property and City Hall were posted on 7/11/22. The affidavit of posting was completed. This property was cited for excessive growth, acquiring a rental license, certificate of use, and outdoor storage. I have not been in contact with the property owner. As of this morning, the property has complied, outdoor storage and the excessive growth. However, they have not obtained the rental license and complied a certificate of use. Therefore, the city is asking for an additional 60 days for them to come into compliance.
If they do not come into compliance, then the city is asking for a $100 a day fine until compliance is achieved.
Do these photos accurately reflect your observations of the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents and evidence. The city's composite exhibit 1. So the only thing outstanding here is the rental permit?
Yes.
And how do we know this property is being rented?
I spoke to the tenant, actually.
Oh, it's pretty good evidence, right? So you actually physically spoke to the tenant?
Yes, they came out when I was taking pictures. And there is evidence of a delinquent money being owed in our systems as well.
Fair enough. In case CE 22060091, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 18162A and 2232A. I give the respondent 60 days to come into compliance or fine of $100 per day may issue.
Thank you.
Agenda item number 13, case number is CE 2203-0520. The case address is 3805 Broadway.
Good morning.
Morning.
Officer Phil Cartwright, City of West Palm Beach Code Enforcement. The property at 3805 Broadway was originally cited on February 29th of 2022 for painting of boards with the completion of a boarding certificate, securing vacant property, securing of vacant property requirements, correction of the violation within 10 days, and failure to comply. Service was achieved by certified mail. The property was posted on February 29th of 2022, as well as City Hall. All violations are still current. Back on April 8th of this year, I did make contact with the owner of the company, Mr. Robert Morris, who called me to let me know that he did receive the notice of violation and that they were going to remove all of the boards from the windows and make the hotel operational before June of this year. But as we can see, none of that happened. The city is asking that the property come into compliance within an additional 20 days or $250 per day thereafter.
Do these photos reflect your observations of the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept and evidence those documents. The city's exhibit 1. So are all these sections currently outstanding?
Yes, sir, they are.
This is a hotel?
Yes, it is. It's been an eyesore after it closed down, probably I'd say maybe a couple years ago. So there's a new owner now, and normal practice is what we would do with a situation like this is we would cite them and have them repair all of the doors and windows. But with the changing of hands with a new owner, we have to give the new owner proper service and have them obtain a boarding certificate. That boarding certificate will be good for 6 months. After that, then we can come back and have them put in new doors and windows.
Okay. So they have to secure it. All right, fair enough. Have you spoken to him since the one time that he said that he would he'd fix the property?
No, sir, I haven't. And I've left several messages for him too as well.
All right, in case CE 22030520, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18214A, 18214B, 18214C1, 18215A, and 18215B, and 18265. I make further finding. I give the respondent, what were you asking for, 20 days?
Yes, sir.
20 days to bring the property into compliance or a fine in the amount of, I'm sorry, what did you ask for, 150?
250.
I'm sorry?
What did you ask for, 250?
Yes, sir, 250.
A fine in the amount of $250 per day may issue.
Thank you.
Special Magistrate, we have respondents present for agenda item number 1. It's already been heard, and the building inspector is unable to come back, so I'm not sure how you'd like to proceed. If you'd like them to give them a chance to respond, or if the order stands.
Does the city have a preference on this?
However you'd like to handle.
Well, I
Review
can't
the
hear it
case.
without the city. Is there anyone else that can represent the city here?
It's a building inspector, so I'm unsure.
I think it would have to
If-
be reheard. Do you have any knowledge of this case?
I do not, but we could look up, we could look up, basically it's for work without a permit, so we could look up the fact that there's no permit.
The
if
building
you want.
inspector did indicate he would be available to be called. He's already out in the field, I guess, so he could be,
I could see if somebody's over there who could come over then.
okay,
Okay.
All right, let's do that then.
okay. Okay, agenda item number 14, case number is CE 22050297. Case address is 1255 Palm Beach Lakes Boulevard, and it's complied. Agenda item number 15, case number is CE 22050302. The case address is 1333 Palm Beach Lakes Boulevard, and it's also complied. Agenda item number 16, case number is CE 22050307. Case address is 1455 Palm Beach Lakes Boulevard, and it's also complied. Agenda item number 17, case number is CE 22060092. Case address is 549 21st Street, and it's rescheduled. Agenda item number 18, case number is CE 22060210. Case address is 1025 22nd Street, and it is rescheduled. Agenda item number 19, case number is CE 22040354. Case address is 720 Francis Street, and it is complied. Agenda item number 20, case number is CE 22050248. Case address is 4200 Georgia Avenue, and it's complied. Agenda item number 21, case number is CE 22050252. Case address is 4250 Georgia Avenue. It's also complied. Agenda item number 22, case number is CE 22050255. Case address is 5003 Garden Avenue. It's also complied. Agenda item number 23, case number is CE 22050303. Case address is 313 Pine Terrace, and it's also complied. Agenda item number 24, case number is CE 22050315. Case address is 4105 Washington Road.
Richard Pasmino, City of West Palm Beach Code Enforcement. This property was cited on May 26th. Certified mail was sent out May 25th. It was signed, received May 31st. In addition, the property and City Hall were both posted on May 27th. Notice was also sent by first-class mail. This property was cited for rental license and certificate of use required. That's wrong. No. I first noticed there was a for rent sign in the yard. 24. And I have had contact with the owner. He did apply for the rental license and certificate of use, but he has not paid the fees and has not scheduled the inspections. He is planning on getting in contact with me early August to try and schedule the inspection. The city's recommending 30 additional days to comply or a fine of $100 a day.
So there's a sign, there's a sign on the property indicating that it's going to be rented?
Yeah, it should be
Trying to
there.
find a renter? And the owner has indicated to you that he's attempting to rent the property?
Yes, right there.
Do these photos accurately reflect your observations of the property?
Yes, they do.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those into evidence, the city's composite exhibit 1. In case CE 22050315, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 18162A and 2232A. Respondent has 30 days to come to compliance or fine of $100 per day may issue.
Agenda item number 25, case number is CE 22060231. Case address is 904 Summit Boulevard, and it's complied. Agenda item number 27, case number is CE 22060305. Case address is 5821 Churchill Court.
Richard Pasmino, City of West Palm Beach Code. This property was cited on June 24th. Certified mail was sent out June 27th. It was returned. July 6th. Property and City Hall were both posted on June 29th, and first-class mail was also sent out. This property was cited for unpaved parking and inoperative vehicles. That's the wrong one. The property is keeping inoperative vehicles on their property, and they're being parked on the grass in the front yard. I've had no contact. As of yesterday, the property is still in full violation of both codes. The city is recommending 10 additional days to comply or a fine of $100 a day.
And if you would give just one moment, we'd like to pull up the photos.
So there was an expired tag on one of the cars, and on the other side of the house, they have a car with no tags at all, right there.
That car's still there?
Yes, it is. That one's still there. The other one was removed, but that one's still there, and another car is on unpaved parking. That's it yesterday.
Do these photos accurately reflect your observations at the property?
Yes, they do.
We would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept and evidence those documents as City's Composite Exhibit 1. In case CE 22060305, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 94482A and 34102A. Respondent has 10 days to come to compliance or fine of $100 per day. May I issue?
Thank you.
Agenda item number 28, case number is CE 22060325. Case address is 4401 South Flagler Drive, and it's complied. Agenda item number 29, case number is CE 22040267. Case address is 7617 76 Way.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On April 20th, the property at 7617 76th Way was cited for rental license violation and certificate of use. Property was posted June 13th, 2022. Certified mail as well as regular mail was sent April 21st. Certified mail was received April 26th. I had made no contact with the property owner, but I have made contact with the tenant. They called me the day of posting, requesting what the notice was in regards to. With that being said, city's recommending $200 a day till compliance is achieved. 30 days to come into compliance. Or $200 a day until compliance is achieved.
Was that notice of violation posted at both the property and City of Hall?
Yes, an affidavit of posting is also attached in the case notes.
And do these photographs accurately reflect your observations at the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents as evidence as City's Composite Exhibit 1. So I've been giving 30 days and $100 a day generally on these cases. There's something about this case that rises to a level that would warrant $200?
Normally with, we usually do that with renewals. Usually, new rentals, we request 200. Unless something has changed.
So this is a new one?
Yes, sir.
Have you had any contact with the owner?
No, sir.
And just that one contact with the tenant?
Yes, sir.
All right, in case CE 220402267, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of 2232A, 18162A. Give the respondent 30 days to come into compliance or a fine of up to $200 per day measure.
Agenda item number 30, case number is CE 22050104. Case address is 1109 Green Pine Boulevard, Unit H1.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On May 11th, the property at 1109 Green Pine Boulevard, Unit H1, was cited for rental license violation, renewal, and certificate of use. Property was posted June 13th. Certified mail as well as regular mail was sent out May 12th. Certified mail was returned June 6th. I did confirm with the management of the property that the property is still being rented. I have made no contact with the property owner. With that being said, city's recommending 10 days to renew rental license or $100 a day until compliance is achieved.
Was notice posted at the property and at City Hall?
Yes, ma'am. Affidavit of posting is attached in case notes.
And do these pictures accurately represent your observations at the property?
Correct.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, those documents are entered in evidence of city's composite exhibit 1. So all they really have to do here is pay the outstanding renewal balance?
Correct.
And the property management confirmed that the property is being rented?
Correct.
Just because I know how the mail works in this particular days, I'm going to give them 14 days.
That's fine.
In case CE 220500104, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of 2232A and 18162A. Respondent has 14 days to come to compliance or a fine of $100 per day may issue.
Agenda item number 31, case number is CE 220500178. Case address is 4431
Embarcadero
Drive.
Embarcadero.
Thank you.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On May 17th, the property at 4431 Embarcadero Drive was cited for clean and sanitary, excessive growth, landscape maintenance, commercial enclosure, doors need to remain open when not closed when not in use, trees obstructing right-of-way, and prohibited trees found on property. Property was posted as well as City Hall on June 9th. Certified mail was sent May 18th. Certified mail was received May 20th. I have made no contact with the owner. They have made some attempts to cut some of the overgrowth, but they have not made attempts to cut back any of the trees. Trash is still evident on the property. As you can see, the huge pile there. There's still prohibited trees on the property that have not been removed. And they refuse to comply with the commercial enclosure. Dumpster is still in view. With that being said, city's recommending 45 days to come into compliance or $100 a day until compliance is achieved. I did cite this property once before in the past, and I did get good response, but it seems that they may have new management for this property, and they're not making any attempts to reach out to me.
Well, that's disappointing.
Do these photos reflect your observations at the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents and evidence as City's Composite Exhibit 1. So as of now, there is still there's still trash and debris around the property.
Correct. And prohibited trees as well.
Is the grass and weeds still in excess of 6 inches?
I mean, they did make an attempt to cut it. I mean, it's new growth, so I know they made an attempt to cut the grass. But, I mean, there's other vegetation on the property that's being neglected.
So there's other weeds and grass that are more than 6 inches?
Yes.
The trees still need to be trimmed and the dead vegetation still needs to be removed?
Correct.
Still need mulch?
Correct.
Is the dumpster still in view?
Correct.
See, that seems like an easy one to fix, doesn't it?
If someone would just pick up the phone and call me, we can get this thing hashed out.
Is the vegetation still blocking parking spaces?
Yes, that hedge is still overgrown into the parking space.
Tell me about this prohibited tree thing. What's prohibited and where is that?
They have some carrot wood on the property as well as some umbrella trees there as well. Yep, right there. That's mostly carrot wood there.
Those are not part of the landscaping permitted?
No.
All right, KCE 2205017A, I make the following findings of fact and law. If a notice is sufficient, I find the property in violation of 18106A, as there is trash and debris on the property, 18106B, as there is vegetation, grass, and weeds that exceed 6 inches in height, 18106K, as there is dead vegetation and areas that need mulch, 7434A2D, as the dumpster is not properly screened from view, 7404C4, as there is vegetation blocking parking spaces in the sidewalk, and 944454I, as there are prohibited trees on the property. I hereby give the respondent 45 days to bring the property into compliance or a fine of $100 per day may issue.
Agenda item number 32, case number is CE 22050192. Case address is 5187 Ellery Terrace.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. The property at 5187 Ellery Terrace was cited for a trash can violation. Property as well as City Hall was posted May 24th. Certified mail was sent May 19th. Certified mail was received May 21st. The reinspection date for this property was May 24th. Property came into compliance June 21st. With that being said, the city is recommending a finding of fact on this property.
Do these photos reflect your observations at the property?
Correct.
And the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll enter those documents to evidence of City's Composite Exhibit 1. So they had the garbage can there out in front of the garage, it looks like, right?
Correct.
And you gave them a notice to screen or at least place it out of view? And you gave them a certain
Correct.
amount of time to do that?
This is the same neighborhood that I have constant issues with. They're required to store the trash can in the garage, and a lot of homeowners refuse to get the garbage can removed in a timely fashion.
So in this particular case, you gave them time to do it, they didn't do it,
Correct.
but they have since done it.
Correct.
Okay. After the required, okay. All right, CE 220509192, make the following findings of fact and law. If I notice is sufficient, find the property has been in violation of Code Section 7434A1J, but has since come into compliance, but after the required compliance date.
Agenda item number 33, case number is CE 22050197. Case address is 5181 Ellery Terrace.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On May 17th, the property at 5181 Ellery Terrace was cited for a trash can violation. Property as well as City Hall was posted May 24th. Certified mail as well as regular mail went out May 19th. Certified mail was received May 21st. Reinspection date was 5/24. Property came into compliance June 21st. With that being said, city's recommending a finding of fact on this property.
Do these photos reflect your observations at the property?
Correct.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents as evidence as city's composite exhibit 1. Case CE 22050197, I make the following findings of fact and law. I find notice is sufficient to find the property was in violation of Code Section 7434A1J, has since come to compliance, but after the required compliance date.
Agenda item number 34, case number is CE 22050239. Case address is 864 Blue Ridge Circle, and it's complied. Agenda item number 35, case number is CE 22050242. Case address is 545 Green Springs Place, and it's complied. Agenda item number 36, case number is CE 22050309. Case address is 5244 Fox Trace. Excuse me.
Good morning. City of West Palm Beach Code Compliance Officer Paul McFarland. On May 25th, the property at 5244 Fox Trace was cited for tree trimming standards and shaping of trees prohibited. Service was achieved by notice being mailed and certified mail sent May 26th. Certified mail was received May 28th. I did make contact with the property owner. We had a conversation with the violations. The property was inspected June 27th, and compliance was obtained July 18th. With that being said, the city is recommending a finding of fact, and I am also in agreement with the finding of fact with the property owner.
Was notice posted at the property and at City Hall?
Service was achieved by certified mail.
Is there an affidavit of posting?
There should be just a certified mail receipt in the case notes.
Okay. And do these photos reflect your observations at the property?
Correct.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents and evidence as city's composite exhibit 1. How did they come into compliance? I guess once a tree is cut, it's cut, right?
Basically, it's hard. I mean, the vegetation is returning to the tree, so I wanted to use this as a learning tool rather than find them for it, because I mean it's not severe. The vegetation, like I said, is returning, so this is why we're requesting to find the fact. That way, the property owner knows that the trees cannot be cut in this manner, and if it is done again, we can bring it back for double the fine, and he's aware of this.
Repeat violation.
Yes,
Yeah, it looks
sir.
like a pretty good hat rack, huh?
Yeah, it's not. I've seen worse.
It's not ideal, huh? In case CE 22050309, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 944462B1 and 944462B4, but since come to compliance, but after the required compliance date.
Agenda item number 37, case number is CE 22050310. Case address is 5224 Fox Trace.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On May 25th, the property at 5224 Fox Trace was cited for tree trimming standards and shaping of trees prohibited. Certified mail as well as regular mail was sent May 26th. Certified mail was received May 28th. I did have a conversation with the property owner. Reinspection date was 6/27. Compliance date was July 18th. Vegetation is starting to return to the tree. With that being said, city's recommending a finding of fact on this property.
Is this a different tree at the same property?
No, it's a different property.
Oh, it looks like the same address as the last case.
I know. It's not. It's a couple
I see,
numbers off.
5244, 522.
Exactly.
Excuse me, I'm sorry
It's a
for
couple
that.
numbers off.
Is there an affidavit of posting for this property?
Actually, there's a certified receipt signed in the case notes.
Okay. And do the photos in the file that we've been reviewing, are those consistent with your observations at the property?
Yes, ma'am.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept those documents and evidence, city's composite exhibit 1. You know, structurally and procedurally, I think it's probably, I mean, I'll do a finding of fact here, but it's probably better just to do these as irreparable, because fundamentally what they did can't really be fixed. You just hope
I
it
agree.
comes back.
I agree, but
Yeah.
sometimes certain circumstances, so that's why I just want to get them opportunity to use this as a learning curve.
Well, you know, it's, you know, we have different roles. Your role is to figure out what you think is appropriate to ask for, and my role is to figure out whether I should, you know, whether there's evidence to support that. So I don't mean to second guess, but typically these are sort of done that way.
I agree.
Yeah.
I agree.
Yeah. All right, case CE 22050310. I make the following findings, fact, and law. I find notice is sufficient from the property in violation of 944462B1 and 944462B4. Property has come into compliance, but after required compliance date.
Agenda item number 38, case number is CE 22050348. Case address is 5148 Ashley River Road.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On May 27th, the property at 5148 Ashley River Road was cited for a repeat violation. Original order issued February 17th, 2022. Compliance of that, inspection of that original order was January 28th, 2022, and that order came into compliance February 11th, 2022. The violation is trash can placement. The property was posted June 14th, and City Hall was posted on June 14th. Certified mail as well as regular mail was sent June 1st. Certified mail was received June 3rd. The reinspection for this property came into compliance on June 10th. Was out of compliance for 14 days. And city's requesting a $50 a day fine, totaling $700.
Do these photos reflect your observations at the property?
Correct.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
This is just trash can day, isn't it?
Yeah, but this this one was a little different. This one actually came in as a complaint because I did cite this property numerous times to remove the trash can from the front yard and store it into the garage. He decided to remove it and put it into the common area where it can be viewed by his neighbor. And he did call me with that complaint.
All right, for the record, I'll accept in evidence the documents listed by Council Cities Composite Exhibit 1. So there was a previous case here where they were ordered to comply with the trash can issue, right?
Yep, there was a finding of fact on that one.
So how many days of noncompliance do we have here?
14 days.
And what was the fine you were seeking?
$50 a day, totaling $700. If my math is correct.
Yeah, that's right.
Yeah. At least that's what my math says too, so either we're both right or we're wrong.
My calculator says that's right.
I presume the reason that you're seeking this is because the violation appears to be willful?
Say it again?
The violation appears to be willful, they're intentionally doing this, I guess is why you're seeking the fine?
Yes, he refuses to listen to every plea from the homeowners association, from me. So, I mean, this is why we do what we do.
All right, case CE 22050, well, just before I do that, have you talked to the homeowner here?
No, they refused to contact me.
Okay. In case CE 2205034-8, I make the following findings of fact on life. I notice is sufficient to find the property in violation of 7434A1J. I make further findings said violation is a repeat violation under 2635B. I find the property out of compliance for 14 days. I assess a fine of $50 per day for a total fine of $700.
Agenda item number 39, case number is CE 22060084. Case address is 3590 Village Boulevard, and it's complied. Agenda item number 40, case number is CE 22060275. Case address is 771 Village Boulevard, Unit 206.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On June 23rd, the business at 771 Village Boulevard, Unit 206, Hearing USA, was cited for business tax receipt renewal and certificate of use. On June 6th, notice was hand-delivered. Certified mail as well as regular mail was sent to the business owner as well as the property owner on June 23rd. Certified mail was received June 28th. I've been in contact with the business owner. She did state that a check was cut and being mailed to the City of West Palm to satisfy the outstanding bill, but we have not received that bill as of yet. So city's requesting 15 days to bring the business into compliance, or a one-time fine of $250 for the business tax receipt and $100 a day for the certificate of use.
I'm sorry, please state the request again. So you wanted $100 per day for the certificate of use, and you wanted a one-time fine of what?
One-time fine of $250 for the business tax receipt.
And what kind of time frame were you looking for the certificate of use?
15 days.
Are there any photos of this property?
Say that again?
Are there any photos of this property?
There should be one of the business. That's the hand delivery, the outside, and there should be another one that was taken, yesterday.
Okay. And the photos reflect your observations at the property?
Correct.
The city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll accept documents and evidence. Those documents as City's Composite Exhibit 1. So she said she was going to send you the check, but she hasn't, huh?
Nope. The thing is, this is a recurring event for this business.
Appears to be. All right, in case CE 2206027, make the following findings of fact and lifeline notice is sufficient. Find the property in violation of 2232A and 82144. Respondent will pay a one-time fine of $250 for the violation of for the violation of 82144. And the respondent will pay, has 15 days to come to compliance for 2232A or a fine of $100 per day will issue.
Thank you.
Are we ready to recall number 1? Yes. Okay. Recalling agenda item number 1, case number is CE 2203043. Case address is 1481 7th Street. And Special Magistrate, I think some folks need to be sworn in.
Yes.
If you haven't already been sworn in, would you please raise your right hand?
No, you stay here.
Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury and the laws of the state of Florida?
I do.
Yes, I do.
All right, so we're back. Thanks for coming back.
So I brought Assistant Building Official Jim Baker over. He was able to quickly look through the case. He probably needs a little bit more time to really research this. Everybody is doing interviews this morning, everybody else. So the argument of the gentleman who the respondent is that he feels like he should be grandfathered in, but because these sliding glass doors, he claims have been there since 1979, but they're onto a deck with no railing. The building official, I can have him speak. He doesn't know anything about grandfathering anything of that nature in, because they don't want to try to waive any kind of requirements and then somebody gets hurt, even though it hasn't happened so far since '79. But so. If anything, I say, can we just reschedule this and hear it again at the next hearing? Unless you think.
Sir, can you tell me your name, please?
I'm Donald Gibson.
So the city is saying that they don't know what to do with the question of grandfathering in this particular case. They'd like to reset this and do some research. How do you feel about that?
I don't think that's gonna resolve it. In looking up information about properties and information regarding the grandfathering in, as I understand it, the house was built in 1979. Since that time, there have been no accidents. Children have been raised and are now grown and are now parents. No incidents have ever happened. So I'm asking that this be resolved by allowing it to stay as it is, grandfather in the fact that no railing needs to be built around the garage roof. We don't use that as a deck. It is a deck that leads out from my bedroom slider onto this deck that's basically full of water, probably 6 to 7 months out of the year. It's unusable. I have a downstairs deck and pool at the property. So I have not requested this. This is a part of a code violation that I was cited with. I've resolved all of the other issues, the debris cutting. I had to take burglar bars off my windows. I did that, and I got impact windows on my doors. So I've gone through a lot of expenses to prepare this house to be safe and secure. This railing does not make it safe nor secure, because I restrict the use of that deck. It's not used. So I'm not sure why this cannot be grandfathered in so that I do not have to spend $6,000 for plans, then $2,000 for materials, and then pay laborers or contractor to build the railing. So this is creating a financial crisis for myself, not to mention all of the things I've gone through to get through your digital plan review process, and now I'm stuck. I've spoken to several of the building officials, Mr. Valente, Tom Moore. I am appealing
Yeah,
to
I
the
don't-
magistrate to
Hold on one sec.
recognize that this may be something that can be resolved because it can be grandfathered in. I should not have to do it.
I don't know the answer to that. I'd have to ask the city's building official to give me some sense of how this is dealt with.
You have to come up to the microphone.
Okay. The building official is Robert Brown, and I'm a new assistant, been here 3 months, and I'm not in a position to waive a requirement that one of our senior building inspectors has placed on this situation without conferring with Mr. Brown, and because ultimately it's his responsibility. This could be some sort of litigation down the road if something were to happen and come back. So I'm not the guy who can ultimately make this decision. It needs to be Mr. Brown. So I would suggest that, I've only known about this for the last 15 minutes, that we be allowed to talk to him and see what he has to say about it. And I'm sure that within half a day, he'll come to some decision on that and would be better prepared next time. As it turns out, today they're interviewing for the chief building inspector, and the folks involved in this case are all currently in an interview upstairs, so they're not accessible. It's unfortunate, but that's where we stand.
All right, I'll be honest with you. I don't know what to do with this. So this is what I'm going to do. I'm going to withdraw the previous order when you weren't here, which required a compliance date. So we're going to withdraw that. I'm going to ask this be resent within 30 days. I'm going to ask the city to investigate and research the question of whether or not this building, because of its age, can exist like this, or what the appropriate procedure is. I'm going to ask you to meet with the respondent and talk to his concerns with him as well. But we'll reset it, and whoever's the magistrate at that point will have to make a decision about what to do, because I don't think I have sufficient information here. One thing I'd ask for you, sir, is please make sure those windows are secure during this period.
Oh, they're always secure and locked, sir.
All right. So let's see if we can figure out how to work this out. Otherwise, I'm going to have to make a somewhat arbitrary judgment here with insufficient information, and I don't really want to do that. So reset this for 30 days.
Okay.
Thank you.
I think that's it, right?
Correct, until the lien reduction agenda.
When are we scheduled for 11 or 11:30?
I believe 11:30, special magistrate.
All right, so we're going to be in recess till 11:30.
Thank you.
here. Okay, 5.
Are you guys ready?
WPB-TV, 30 seconds.
Hi, Cassandra, I'm Liz Alter at 2020 Sugar Hall. I just, nice to put a face to the name.
All right, I hereby call this meeting back into order. This is the special magistrate hearing, other matters agenda. The cases are going to be heard in the order in which they appear on the agenda. When you hear your case called, go ahead and proceed to the podium on my right-hand side. The city is going to present the case. Then you'll have an opportunity to speak to me. If this is a fine reduction, I'm going to ask you to tell me what you're asking for and justify why I should grant that to you. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply. However, all testimony is taken under oath under penalty of perjury. So with that said, if you're going to testify today, or you think you might testify, or there's a possibility that you might testify, I'm going to ask that you rise and raise your right hand. And repeat after me. Or not repeat, but just confirm the following. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes, sir. All right, please be seated. All right, the city can call the first one.
Okay. Agenda item number 1, case number is CE 1401029. The case address is 524 Deterra Street.
Case CE 140102229 was issued a stop work order on December 13, 2013. After a failure to obtain the proper permit, the property was cited on January 14, 2014 to obtain a building permit. On March 26, 2014, the magistrate ordered 30 days or $100 a day to obtain permitting. The property failed to comply with the magistrate's order and was out of compliance for 80 days, resulting in a lien amount of $8,000. The city is seeking 25% in this matter, being that the applicant is the cause of violation. Also, I wanted to point out on the applicant's application, they stated that the reasoning that they weren't able to commence the work was due to Brightline doing the work. But if we look at the timeline here, stop work order was issued on December 13th of 2013. Brightline didn't begin work until November 2014. And even with that, the city was more than generous in giving extensions to get all they needed to do was get the proper permitting, not even commence the work to get it done, and it still was not finished on time.
Sir, can you tell me your name, please?
Yes, I'm James Werder, attorney for the client City Place, North Florida, LP. I'm here representing Kraska Law Firm, the law office of Kraska Law Firm, which is the representing attorneys. Yes, Your Honor, I'm sorry, I'm the one who worked on this application, and I think maybe I was a victim of the whisper game. When you talk to too many people, you get different timelines or whatever. But yes, back in 2014, the violation was noted and repaired. They were working with, hang on one second, I forgot her name. Anna Maria Ponte. I don't know if she's here today, but at that time she was the city planner. So at that time it was corrected, and understanding that they didn't have a permit, they went back, got a permit to fulfill the needs, and the thing had been corrected. We applied a year ago, and then some other things popped up on other properties, and we the 90-day window for having a hearing expired, so this is a reapplication. Brightline, as my understanding now, did come in later that my client was working with to help them get the things fixed on that particular alley, I believe, and there was another building next to it. It was very convoluted, but they weren't aware of the rolling lien and the violation until they started working on their contract for sale. And then when I applied, then all these other things came up. There was two issues of, one, taxes not being paid by a business tenant, and then utilities, what year was that in? Utilities?
2010.
I'm sorry, I have here with me Catherine Solo, who is representing the company as well. And in talking to her, we got things kind of straight this morning.
Is she an attorney or is she a?
She's just the client that came in representing the party representing the client.
City Place North Partners?
Yes.
Okay.
And so what we're asking here today as an act of good faith, because we were working hard to get all these things cleared up, and we thought we did in a timely fashion. It was just a discovery issue back in 2014 forward. They didn't know about the existing lien on the property, which came at the time of the contract, or researching the contract for sale, right?
Just about a year.
Yeah, so we're asking for either an elimination or a substantial reduction if you need to fine us a good faith fine. I believe the outstanding amount is $8,000?
Yeah, that's the lien amount currently.
Yeah, so, I mean, if you need to do a token fine, we would ask for the minimum, 1,000 or something like that. But everything here was being done in good faith, and just some sort of notification slip the,
The city offered to reduce 75% to $2,000. That seems reasonable to me.
2,000? Very good. Thank you, Your Honor.
All right, we're gonna, how long do you guys need?
How much time do you need to write a check?
I'll give you 30 days.
Hey, say
All
about
right,
30
reduced to $2,000, 30 days payable.
Okay, very good. Thank you much. You'll have a good day.
Day. Moving to agenda item number 2, case number is CE 1507-0899. Case address is 616 Clearwater Park Road, Unit 408.
Good afternoon. Attorney Julie Karen from the law firm of Shendell Pollock, representing Florencia Eugenia LLC. And I have with me...
I'm sorry, one more time, your name was?
Julie, Karron, from Shendell Pollock.
Okay, go ahead.
Okay, thank you. And this is Ariel Giglio. He is here as the applicant on behalf of the entity as well. Florencia Eugenia LLC.
He's a representative of the LLC?
Yes.
Okay.
So this,
Hold on, let me let the city just present what they have, and then I will let you ask me for whatever it is that you'd like to ask me.
Case CE 15070-889 was cited on March 31st, 2015 for failure to obtain a rental license and certificate of use. On October 21st, 2015, the magistrate ordered 30 days or $100 a day to achieve compliance. The property was out of compliance for 1,359 days, resulting in a lien amount of $135,900. The applicant is the owner who caused the violation. The city is seeking 25%.
Okay, go ahead.
thank you, Your Honor. In this case, we just learned about the existence of the lien when the entity attempted to sell the property. It ended up actually causing the sale to not go through, and a resulting lawsuit that I individually was defending on their behalf. So they've already suffered a lot for this. They weren't aware of it. I think we're talking about like a $60 license fee that was paid in the subsequent years. There was some sort of issue through excusable neglect where they didn't know about it, and then it continued to accrue at $100 a day for the 1,000-something days. This is an entity that was affected by COVID. They do own 2 properties in West Palm Beach, both of which have been inhibited by the lien and encumbered, and we've had to work on resolving the lawsuit because we weren't able to sell the property, so we were sued for breach of contract. So we request that we be just charged the $60 back fee and be allowed to eliminate the remainder.
Well, I'm not going to do that, and I will tell you why I will not do that, is because we're on TV, And it's important, right, that people watch this, that they understand when the city code enforcement comes and issues a notice of violation, that they be taken seriously, and that the respondent attempt to bring those into compliance, especially if there's not an issue that it was noticed properly. What I can't do is I can't, especially with everyone sitting in this room, tell you that when you let something go for, what was it, 1,300 days? Or 1,300 days?
1,359.
1,359 days without coming into compliance, that I'm just going to say, hey, pay $60.
They just weren't aware of it, that was the problem.
How was notice accomplished here?
Certified mail postings per usual. And just to touch base on what they mentioned here, they do own another property in the city, and and that also was, I believe, was cited for not having rental license in COU, and that was complied. But here's the thing, with not properly getting your licensing, it does impact the neighborhood. And with the individuals that you bring in to rent these properties, they're not being properly vetted. There is a system with applying for a rental license to make sure that the people that you bring into the community, into the neighborhood, that kids, other residents can be around them for safety reasons. So when you don't get the proper licensing and the city is not aware of what's going on, it's a big impact to the neighborhoods. So I understand that there was maybe a lawsuit for breach of contract, but that does not include the city. And I believe that a 25% is a generous offer, being that the property was out of compliance for 1,359 days. This is not a new rule in the city of West Palm Beach. There are several other units in this particular property that got their licensing. So, ignorance should not be the excuse here.
Right, and I could respond to that this isn't a condominium that does require an application and approval through the condominium. So hopefully that would address your concerns as far as vetting the tenants and things like that. However, the license was paid for in all of the subsequent years. They just didn't realize it was behind. If there was a past due, that would have been, of course.
Well, it has to be more than one subsequent year, since it was 1,359 days that it was in.
But it's paid current, and it has been ever since. This is just one that somehow slipped through the cracks through excusable neglect.
Let's note, this was not a renewal of license. This was a violation to obtain the license.
Right.
So you were paying for something you did not have. There, at no point did a inspector go into the property to ensure that the minimum housing standards were met. So you were in violation, and you were in violation for years. Again, I understand everything that happened, we can put COVID into it, but that has nothing to do with the city. This was cited back in 2015, and it was resulted in 2019. August 13, 2019. This was prior before lockdown of COVID. So really, that has no bearing on this case right now, just being honest here.
Well, the city has offered to reduce it by 75%, which, if my math is correct, would be $33,975.
Yeah.
And that's still a significant amount for a $60 fee.
Well, to be honest, you haven't made me a reasonable offer.
Could we do 5%?
What is 5%?
I gotta do the math. 7,000.
$6,795 to be exact.
Oh, thank you, Chief.
It's a pretty substantial fine. It went on for a long time. This is what I'm willing to do. I'll reduce it to $10,000. And I'll give you 90 days.
Thank you, Your Honor.
Moving on to agenda item number 3, case number is CE 200800297. Case address is 2417 Spruce Ave.
Case CE 200800297 was cited on August 26, 2020 for failure to secure a building permit and required inspections, certificate of use, and business tax receipt. On October 7, 2020, the magistrate ordered a finding of fact on Code Section 105.1, 110 FBC, a 7-day compliance or cease and desist order, and a fine of $250 per violation. The property was out of compliance for nine different days, resulting in a lien amount of $2,250. The city is seeking 25% in this case.
Ma'am, can you tell me your name, please?
Lydia Stevens.
So what are you asking me for, and why should I grant it to you?
We fix everything. And
See, I do know that because you can't be here unless you're in compliance.
yeah,
So I know everything is fixed. The city has offered, what's 25% of,
You give me
$562.50.
how much?
$562.50.
The city has offered to reduce it to $562 and change. I think that's fair.
Yep.
All right.
Thank you.
So I'll accept the city's offer. We'll reduce it to $560.69, did you say?
50 cents or 60 cents.
50 cents, fine. There we go.
Okay, thank you.
How much time do you need?
A month.
30 days. 562.50 cents.
50,
50.
50.
50. 562 and 50 cents. I should have just rounded it to an even number. I don't even know why. Whatever. Math challenged.
Okay, moving on to agenda item number 4. Case number is CE 21060436. Case address is 5301 South Dixie Highway.
KCE 21060436 was cited on June 25th, 2021 for failure to obtain a building permit, work commencing prior to obtaining a permit, and required inspections. On September 15, 2021, the special magistrate ordered 90 days or $100 a day to comply. The property was out of compliance for 28 days, resulting in a lien amount of $2,800. The applicant is the owner who caused the violation. The city is seeking 25%.
Can you tell me your name, please?
Hi, my name is Natalie Bach,
Natalie.
Bach, B-A-K, and I'm a representative of the owner.
You're the representative of the owner of South Dixie Partners?
Yes,
And what is your role with South Dixie Partners?
I am the construction manager who was hired in July of last year. The stop work order was issued in June of last year. So
You were the one that had to clean it up, huh?
Exactly. So the original GC who was hired to complete the renovation on this building did not obtain any permits. And subsequently, I had a very difficult time having my subcontractors come out and certify their work.
I'll bet you did.
So I did appear before you in September requesting 90 days, and unfortunately, it did take me a little bit longer to get this cleaned up. I had 2 out of the 3, issues handled ahead of the deadline, but there was just one that kind of lagged a little bit, I believe due to the holidays. So I was not aware the city is just requesting 25%. I was gonna ask that it be eliminated, but maybe we can kind of split the difference and go for like 12.5%.
I mean, if we're reducing, the city's asking for only $700 of $2,800. That's 25%.
I actually think all things considered, the city's offer is pretty fair here.
Okay,
How much time do you need?
30 days, please.
All right, I'll reduce this to $700 payable in 30 days.
Thank you.
Moving on to agenda item number 5. Case number is CE 21080273. Case address is 2020 Chagall Circle.
KCE 21080273 was cited on August 19, 2021 for failure for location of the artificial turf and installing artificial turf. On September 6, 2021, the magistrate ordered 60 days, $100 a day to achieve compliance. The property was out of compliance for 65 days, resulting in a lien amount of $6,500. The applicant is who caused the violation. The city is seeking 25%. But magistrate, I just wanted to give a bit of background on this particular case.
Okay.
This case here, honestly, could have been easily solved. This is what happens when we have a violator failing to communicate with the code officer. I have Code Officer Paul McFarlane here who will testify on what happened with this case for them to get the lien. But the issue we've noticed with this organization is instead of reaching out to the actual code officer or the people who can help them and complying, they would much rather play, I guess what you would call radio. They called all around the city just to not comply with the magistrate's order. And that's how the property ended up 65 days out of compliance. Paul McFarland will testify as to what happened to lead to these violations.
Sum it up, Officer McCollum. So tell me what's going on here.
Code Compliance Officer Paul McFarland. Back when this did originate, it did come in originally as a complaint. Notice was sent. It's in normal fashion. When I did make contact with I believe the person's name was Charles and Elizabeth, I quickly let them know that to not complicate things was to go ahead, remove the artificial turf, sod is going to need to be installed, and irrigation installed. I then let them know that irrigation may require permits. Instead of following my direction, they just decided to discredit everything I tried to explain to them. And this is what drew everything out, and this is what complicated compliance. Because now building gets involved and all work has to cease until they obtain the permits, which I tried to avoid for this all getting entangled and them accruing a lien. And this is what I just wanted the input is, if they just followed my direction, it would have never ended up here. And the thing is, I have no control of what people want to do when they do get a notice, but I do go all over and beyond to get the property into compliance. I give them every scenario that I can think of that could complicate things, and this was one of them. At the end of the day, things got convoluted, tied up with building, and this is where they earned the lien because of building getting involved. But if they would have taken my direction and just went to building, it could have been resolved quickly, which when it did get resolved quickly, but it was after the fact. So this is where the lien accrued. So with that being said, I just want to go on record to show that if they would have contacted me and followed my direction, it would not have been here.
All right, can I have your names, please?
For the record, my name is Chuck Millar. I'm a senior project manager with Atwell, and with me is one of the board members, Liz, from the Classics of Bear Lakes HOA. And
Sorry, sir, your name was?
I'm sorry?
Your name one more time for me, please?
My name is Chuck. The last name is Millar, M-I-L-L-A-R, and I'm a senior project manager with the firm of Atwell.
And you worked on the replacement of this artificial turf, sir?
I'm sorry?
You worked on the replacement of this artificial turf?
Yes, I was brought in to help assist with this, dealing with the replacement and bringing the site into compliance with respect to the original turf.
And ma'am, you're the representative of the HOA?
Yes, I'm Liz Alter. I'm the treasurer of the HOA.
All right, so what are you asking me for, and why should I grant it to you?
So I want to take a brief moment because I respectfully need to make sure that our facts are clear. So I want to walk you just quickly through our presentation because I think this tells a little better story as to the almost a year process we've gone through to be in compliance. And I think I can represent to the city that this site is in full compliance with all applicable standards and requirements of the city of West Palm. I'm going to go through these quickly, page by page. The first page shows you the entry monument sign, and the area around that monument sign was installed with artificial turf. The second picture, the two circles, show you the area, the common portion of the Classics property. And it's that portion along Shenandoah that has two curbed, a monument sign, and landscaping. Third picture again shows that area that's in green where the signs are that was originally installed with turf. As does the fourth picture, is the same area. was originally installed with turf, and we've gone back in and replaced it with sod. The next page shows the additional portion of the median that has now been re-landscaped and brought into compliance. The next document is just historical steps that were taken to bring the site into compliance in the original notice of violation. The next page is a list of the chronological events that we've done. I think that we have done everything that we could do in a process that works for both sides to bring the site into compliance. I want to focus on the bullet points that say at the top 2020 Chagall Circle, that this entire issue was driven by the installation of artificial turf that was then sited and then removed. And what that caused was a series of events to bring the site into further compliance. There was some initial discussion with the city landscape inspector when we asked if we needed a permit to replace landscape material like for a project that's 30 years old. We asked to be provided with, we made a public records request to find a landscape plan and irrigation plan, which was not available, so we had to start over. At no point of any of this clearly was the public's health, safety, and welfare at risk. But the series of events that caused, once the sod the turf got taken out, the sod got put back, then we had to replace 30-year-old irrigation that was broken. So there was some dialogue back and forth with the city that we needed a permit, we didn't need a permit, we were finally told we did need a permit, so we went ahead and did that. So we went through the process of getting a permit to install the irrigation, and then install the plant material, and then reinstall the sod. We've maintained, as you can see on the list, an open dialogue with the city. It isn't quite as easy as it was portrayed just to take out the landscape material and replace it. We had to go through a permitting process. We had to hire a contractor that was licensed in the city. We had to submit design plans. That went through a review process. One of the reasons we missed, and we aren't pointing fingers, but we changed our management companies, and when the notice was issued, we were not present at the hearing. At no point were we ever going to not bring the site into compliance. We've done everything we can. Yes, it's been about a year process, but we wouldn't be here today if the entire site was not in compliance. The HOA's incurred probably close to $12,000 in fees and costs to bring the site into compliance. I think we've had, I lost count of the number of inspections that we've had to get the site where we are today. There was some open permits that we had to get closed. It was a long process that we had to pursue in good faith to get all of the open permits closed, to then have the site inspected again, and then to be eligible to be here today to request that this lien and fine be reduced. So I think it's... Liz, go ahead. Step up.
Sir, I just want to say two things. Sorry. Just want to say two things. When I met with Mr. McFarlane, I thought I was in joy. I thought we were in compliance. I had just pulled the turf out. I did not know that I needed to have the irrigation redone and have, and put grass back down. I thought, again, I came into this, I think the original sighting was August 19th of 2021, and I did not get involved in this until I think it was almost October. One of my residents actually told me we missed the other special magistrates hearing. At that point, I had not even known about that. Otherwise, of course, we would have been here. Regardless of that, when I went to try to work out the irrigation, we were told that we had to go into the city records to get the original documents. So that took time, because that took over a month, I would imagine, I believe. I have the records if you need them, for us to find out that nothing existed. Secondly, once we did that, then we went back and we found out that we needed to have a diagram drawn up, and we finally found a contractor to go in and fix the irrigation. As I said, as Mr. Millar has said, we have worked tirelessly for 10 months. Maybe we did it the wrong way. We hired Atwell to work with us because, frankly, I have no experience with this whatsoever and no idea how to wend my way through the system. And if we did it backwards, lesson learned, but it was not from any reasoning other than we wanted to get this done properly.
So if I understand this correctly, what you're telling me is that you didn't have enough time to do this.
I would say it's more of a case I didn't have enough knowledge to do it. And I, not knowing about the special magistrate's order and knowing what was going on between August and October when I took it over. Yes, if you want to put it that way, I didn't have enough time because for some reason there was a misunderstanding in the community, and I was told, oh, we didn't need to be at the special magistrate's hearing. I learned this after the fact, that everything was already cleared up. Don't know anything else but that, and I'm quoting.
That's generally a bad way to get your news. That's generally a bad way to get your news, especially on legal matters.
I can't agree with you more. I think I put in notes to myself, oh boy, was I wrong. So that was, I agree.
How would the city respond to this?
I just wanted to give a brief timeline, just based on what they stated. So, as Paul McFarland stated, he cited this property back in August 19th of 2021, right? On August 24th of 2021, he spoke with Derek, who was at the time, I guess, worked at for the HOA, and also on September 27th of 2021, he received an email from a Michael Posner on behalf of the HOA about the violations. So this is not, on the city. We've reached out, as Code Officer Paul McFarland stated, he gave directions on how to get this done without having to go through all these loopholes. But even when the property went to hearing on October 6th of 2021, there was still additional time given to have this rectified. But if you look even on the application that they submitted for the lien reduction, they have a timeline of everyone they went to instead to try and get this put out, instead of just listening to the original order that was given by Code Officer McFarland and also the order that was given by the magistrate. I understand sometimes lack of experience could lead to us not doing things properly, and I understand that was not what Ms. Alter was trying to do. But when you have the code officer telling you, hey, do it this way, and you still refuse to do it because you're trying to get another department to say no, that's how you ended up with a lien. This is not code enforcement putting liens on the property just to put it. This is because of lack of communication from the HOA. We did our part, and I think the city is being very generous in asking for just 25%.
May I say one more thing?
Absolutely.
Just for point of record, because I assume this is on the record, Michael Posner is the attorney for one of the residents who is not a board member and in no way whatsoever was ever hired to work to represent the HOA.
Okay. So the city has offered to reduce it from 6,500 to 1,625.
What was it?
From 6,500 to 16, to 25%.
You good?
1,625.
I mean, we would ask for a reduction, but I think on balance, given the fact patterns that.
Yeah, I think it's fair too. All right, I'll reduce the fine from 6,500 to 1,625, payable 30 days. $1,625 even. I've decided not to do change anymore. All right. Last but not least.
Last but not least, agenda item number 6, case number is CE 190200169. Case address is 401 50th Street.
Come on up, sir.
Okay. Case CE 190200169 was cited February 13, 2019 for garbage can placement and outdoor storage. On March 6, 2019, the property was given an additional 10 days, $150 a day to comply. The property was out of compliance for 994 days, resulting in a lien amount of $149,100. The applicant is the cause of the violation. The city is seeking 25% in this matter, but Magistrate, I just want to add a quick note. On this application, the owner themselves, they refer to themselves as absentee. I just want to point out, it is the responsibility of the owner to ensure that the property is in compliance, and if there is an issue with trespassers, it is also the responsibility of that owner to file the proper paperwork with the police department to ensure that individuals who are trespassing on the property are removed.
Or what?
Are removed? Yeah.
Sir, can you tell me your name, please?
My name is Greg Bevilacqua.
And what is your position with Tri-State Partners 50 LLC?
I'm actually a realtor that represented the seller in this, and he wasn't able to make this meeting, so I'm here on his behalf.
So you're the realtor for Tri-State Partners?
I'm a realtor for the property, yes, that I sold the property.
You were hired by Tri-State Partners?
I am.
Yeah. I'm just trying to get your legal relationship with the person in issue here. Technically, realtors are not lawyers. I don't know if the city has any objection to him representing them.
No, the applicant
Did they sign a paper?
designed him as, he's the designated agent
Oh, fair enough.
for the property, yeah.
All right, so what are you asking me for, and why should I grant it to you, sir?
Being that the owner was an absentee, he wasn't, and I guess he never was given notice, or he never received notice, out of state. There was vagrants, homeless, grifter lawsuit. The first 2 weeks he owned the property, he was in the lawsuit. There's burglaries of all different tools and items that were stolen, garbage, etc., left consistently. One person died of an overdose on the property, did everything that possible to try to clean it up, and finally did get it done, and got the property generating tax revenue, and it's not an eyesore anymore. It's a beautiful property on North Flagler Drive.
I gotta be honest, it wasn't terribly persuasive to me. What it suggested to me is that your principal let this property go pretty badly, and the city probably expended a fair amount of resources trying to keep it from being a danger to the community.
I didn't hear you.
That's not terribly persuasive to me for this reason, because it sure seems to me like what happened here was that the owner was absentee and allowed the property to fall in such a state of disrepair that the city probably had to expend a fair amount of resources to try and keep the property from becoming a problem for the neighborhood.
It was, he embarked on a complete renovation of the property from the start, and one contractor to the next, but then COVID came in, second contractor was brought in. In that interim, outdoor storage needed to be, container storage needed to be put, because property, the wires and all kinds of stuff were stolen three times.
That can be permitted with business. I mean, people do construction in the city and aren't fined for it. How long was this property out of compliance?
For 994 days. And I just want to note too, that, I mean, a lot of work was done on the property, as you state, for renovations, but it wasn't for the benefit of the city. It was just so that they could sell the property. I mean, they made $1.6 million off this property. That's really that was their reasoning to really fix it up. It wasn't because
Ms. Sinclair, actually.
Hilaire. Saint Hilaire.
Oh, sorry.
Yeah.
This was, they had invested quite a bit into this property and to get it to where it was. It was in disrepair from the start, and it took them 4 years to get this done through 2 contractors with permits and the whole thing. So, it wasn't as rosy as we're making it to be. Believe me when I tell you.
I imagine it wasn't. What are you asking me for, sir?
We're asking for a reduction to $6,500.
from 150,000. And the city is offering, if I did my math correct here, 37,275.
Yes, sir.
I gotta say, I'm not really persuaded by 6,500 considering how long this property was out of compliance.
Another offer?
Yeah, you're gonna have to do better.
$10,000 US. Please. And thank you.
What's the city's position on their offer of 10,000?
10,000? We'll accept.
How long do you need?
I'll write you a check right now.
All right, I'll reduce it to $10,000, payable 30 days.
Thank you.
Thank you.
Thank you, Mr. Wagner.
I think that's it, yep. Seeing no further business here today, this meeting is hereby adjourned.
All right, bye-bye. Bye, y'all. Oh, Mark, don't forget your computer.
Yeah, yeah. Hey, what's up?
Thank you, everyone.
Yeah.